So per usual, I'm going to call a roll of members of the committee. If you could please just unmute yourselves and say here so we can make sure that your mic is working. I'll then do a roll call of non-committee ACUS members. If you could also unmute and say here, just so that we make sure that your mic is working. So I will go ahead and start with the committee with our chair, Helen Saracio.
Here.
Excellent, thank you. Jim Chen. Jim, I see you're on here. If you're able to unmute just so we can hear you, that would be great. I don't have a mic. Okay. No problem. We'll work around that. Kayla Gammon, alternate for Brooke Poole Clark.
Hello.
Hi. Thank you. Devin Frey, alternate for Daniel Cohen.
Here. Can you hear me?
Yes, thank you.
Okay, perfect.
Jen Dickey.
I just joined. I'm here.
Perfect, thank you. Nick Goldstein.
Here.
Thank you. Courtney Mallon, alternate for Phil Huey.
Here.
Excellent, thank you. Erica Litzen.
Here.
Hello, thank you. Phil Lindemuth.
Here.
Excellent, thank you. Sid Shapiro is going to be late. Ganesh Sitaraman. I don't see him yet. He was tentative. Peter Strauss.
Here I am.
Excellent, thank you. And Chin, we already heard from you, but if you could just unmute and say here again, that'd be great.
Here.
Excellent, thank you. Okay, is there anybody else on the Committee on Regulation whose name I did not call? Okay, seeing none, I will just move forward with non-committee ACUS members. Matt Weiner.
I'm here, thank you, Kaja.
Of course, thank you. And I also saw Laura Barhett. I apologize if I mispronounced that, Laura. It looks like you're not connected to audio, but I do have you down as attending. And then lastly, our consultant, Aram Gavor.
Here.
All right, excellent. So at this point, I would normally turn it over to our chair to provide introductory remarks. I think as all of you are aware, Andy is no longer with us, and our acting chair, Nathan Shaw, had other obligations during this time. So I'm here to provide opening remarks. Just want to thank everybody for being here and for attending and contributing to this recommendation. We have 3 recommendation projects that we'll be considering this season ahead of the June plenary session. So we're looking forward to a great discussion. All of them have great reports and great recommendations coming to all of the committees. So we're excited to have that, and yeah, just excited to get this started. For those of you who don't know me, I'm Kaja Novatsky. I'm the Deputy Research Director at ACUS. I'm also filling in for our regular research director who is on this call, Jeremy Grayboys, since he has been out of the office on extended leave periodically. So just know that he'll be coming back eventually, but I am filling in his shoes for now. So with that, I will turn it over to Helen.
Thank you, Kaja. Good afternoon, everyone. So I will start off by going over the meeting protocols. So please note that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, though, I'd ask that you keep your microphone on mute and either use Zoom's hand raise features or add a comment in the chat feature if you'd like to speak, unless your mic's not working, and then we will work on that too. I'll then call on you and you can unmute yourself. Please then remute yourself when you're done. I'd also ask that ACUS members and their designated alternates use the webcam to facilitate conversation. With respect to attendees other than ACUS members and alternatives, participate requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points and will presume that committee members consent absent the raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you are done speaking. For all participants, please use the chat feature only to indicate that you'd like to speak or if your mic's not working, or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Only members of the Regulation Committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee, and we have a list of committee members in case you are unsure. I will turn it back to Kasia.
Thanks, Helen. So since this is the first meeting of the Regulation Committee to discuss this project on agency investigative procedures, I would like to turn it over to our wonderful consultant, Aram Gavor, to just give a brief presentation on the research that he did underlying the recommendation in the report.
Thanks so much. Very nice to see some familiar faces, meet new ones. I'm Aram Gavor. I'm the academics dean and a professor at GW Law School. And this is my first interaction with ACUS. So if I'm doing it wrong, just let me know. So this project was an interesting one and also builds on a fair amount of my research on administrative investigative processes. The conference laid out that a number of different topics that the report should cover, which I enumerate verbatim and then apply. There's a variety of different ways in which this could have been done. The approach that I chose, because administrative investigative processes don't really have one singular form, and there's a great diversity of different agency processes, functions, statutory authorities, etc., was that I tried to get a decent snapshot of the administrative state by selecting a couple cabinet agencies, a couple independent ones, 2 agencies within the same department. So that'd be like the OFAC as well as the IRS, and really to try to catch a couple through lines and then exercise some sound judgment on what could be appropriate recommendations for this group's consideration. I think of particular import, given the changes in government, is that the data collection phase of this project ended late July, early August 2024. So what you're seeing is a bit of a snapshot of what I observed at the time. So for example, CFPB at the time made a lot of sense to include for purposes of this report. Obviously, there's some changes at CFPB. If what we see in the news comes to bear, there might be some consolidation there. Most importantly, really, I'm grateful to the conference for shedding light on this area of administrative law that is pre-enforcement, at least as I define it, information gathering phase. And I'm available to answer any and all questions you have. And I was asked to keep this to like 2 minutes, so there we are.
Thank you, Aram. I'll turn it back over to Helen in a moment, but also just want to give members an opportunity if they do have any broad questions at this time regarding the report or the research, feel free to ask them now. All right, Helen?
No.
Oh,
No.
hi, Peter.
No, it's okay. So I'm wondering to what extent you considered, one, the use of artificial intelligence, because I didn't see anything in the recommendation that reflected the use of artificial intelligence, and particularly in the processing of what I describe as electronic submissions. It seems to me that a lot of agency investigative procedures, particularly going forward, will be the product of data that comes in and gets processed through artificial intelligence, and then signals come out that, okay, here's a problem or the like. One of the things that comes to mind, if smokestacks continue to be monitored by EPA, which of course is an open question, but if smokestacks continue to be monitored by EPA, they will have, if they don't already, they will have in them devices that report to the EPA what's coming out of the smokestacks. And EPA will have that data, and it will get processed in an artificial intelligence sort of way. And out of that will come, I suppose, you could describe that as an investigative procedure that will lead to complaints, or not. And so that's the question, whether to what extent you considered, or there ought to be considered in connection with this report, the uses of electronic submissions and artificial intelligence.
Hey, Peter, that's a great question. I know it's something that the conference has put a lot of effort in, and I'll let Kaja step in with some of those data. This report does not focus on AI, although personally I'm really focused on AI. Here's just an example of some of my work on it. But to answer your question on its face, no. But of course, there's a lot of upshot with that topic generally.
Well, I mean, just for me to have a report and general consideration of agency investigative procedures that does not take account of electronic submissions and the uses of artificial intelligence in relationship to them. And it needn't be signals from smokestacks. It can be OSHA reports that are filed electronically on a regular basis, and don't get read by individuals, but get read by computers. From my perspective, that is an important and increasingly important element of agency investigative procedures. And, you know, maybe there could be a disclaimer here that we aren't dealing with that. But I think that then that disclaimer will produce some reactions to the recommendations being made.
Peter, I'll just step in here as well and just say that at the last plenary session, the Assembly did adopt recommendation 2024-8, I believe.
-5.
On using algorithmic tools, which includes AI and regulatory enforcement. It does contemplate the investigative procedure as well in that one. So I think maybe we would probably cite this in a footnote in the preamble.
More than a footnote. That is, I'm sorry, I should have been aware of that. Should be aware of it. I'm not. But if that's the case, this is supplementary in some sense to that recommendation that deserves a lot more than the footnotes.
Okay, I will put a note in the red line version for when we go through the preamble to include wording on that recommendation as well and how that applies to this one.
And Kaja, that it would be footnote 2. We already have a reference to it in it.
Oh, super. Thank you.
I will say again for myself, simply having a footnote reference that lists quite a few recommendations,
yep,
rather than a discussion in text of how this set of recommendations relates to that really quite parallel set of issues is just as insufficient.
Thank you.
All right. Well, Helen, if you want to get started, I'm happy to share my screen.
Thank you. And we're going to not start with the preamble because it changes a lot after we get to the text. So we will start with the first recommendation under disclosure and transparency, which is recommendation number 1. we want to start with the first
Yes, I
comment?
was just
Yeah.
adding that comment. So here we go.
Oh, no, take your time.
Okay. And then I just want to make sure everyone can see it okay. Is the text big enough for folks? I'm seeing nodding, so that sounds good. Okay. Um,
All right. So we will give everybody a moment to look at the first recommendation to see if you have any issues with the language or ideas, both granular or high level. Peter?
Well, it's the same thing. So at the end of the first sentence, includes information about investigative procedures, comma, including electronic, including the use of electronic submissions and artificial intelligence.
Thank you. Thoughts, anyone?
so I will just add, if we add this, then the preceding clause would also need to be amended to specify consistent with recommendation 2024-8, or perhaps we would,
Sure.
it's a separate sentence.
Mm-hmm.
I mean, I know that in the OSHA context, the issue of electronic reporting has been a subject of considerable, at least used to be. I've gotten out of contact for a while, but at least used to be a subject of considerable controversy and resistance.
Any other thoughts or reactions to Peter's? And if I miss anyone today, please let me know. I apologize. My computer keeps wanting to reboot. So every now and then I need to hit the thing that doesn't let me do that while we're talking. So I apologize for that.
As a matter of draftsmanship, I would suggest starting with the phrase that begins, agencies should develop an enforcement manual, and then perhaps the references to previous recommendations could be in another sentence or footnote.
So I'll just say that the reason we word this like this is because we already adopted the recommendation that agencies should develop an enforcement manual. So reiterating it as a standalone sentence is kind of duplicative as to our previously issued recommendations, which is why it's phrased this way. If you have a different way of phrasing it that you prefer, I certainly welcome that, but that is why it's phrased in this particular way.
Should include in their enforcement manuals.
Sure.
Information about.
good. Any other thoughts on our first suggested edits?
Are we talking about number 2 yet, or just
We're
one?
still on number 1. Does anyone else have any other suggested edits for what I like to give it as the transparency section, making sure it's easily located on agencies' websites? And then the exception clause for when there's reasons that we shouldn't. Courtney.
Hi, I was just wondering, what exactly were you guys thinking about when you said, or portions of their manual? Were there specific portions that you thought should be on the website, or what exactly was the thought of the committee?
So Adam and I can take this because this was initially drafted by staff. I will just probably defer to Adam on this since he did the first pass, if that's okay, Adam.
That's perfectly fine, Kasia. So when I think about, and this was sort of incorporated as a general idea amongst the staff, when we think about enforcement manuals, one of the caveats that we included in 22.5 was that there are portions sometimes in enforcement procedures that might not be needing or able to be publicly facing if they might undercut agency enforcement procedures down the line. So we wanted to give the recommendation sort of that flavor to give the option that some procedures in these enforcement manuals relating to investigations might be appropriate for inclusion and publicly available, whereas some might not be. I hope that answers your question, Courtney.
Would it help to say something like consistent with the 7th exemption to the Freedom of Information Act? Because I take it that's the issue that is being dealt with here.
We could certainly revisit the FOIA exemption in sort of our approach after this meeting to see what would be best. But yeah, I think that could be appropriate to include.
Yeah, I was just thinking something perhaps more broadly, and maybe just to the extent possible or something like that. I just wanted to verify what was your meaning first, and it was consistent with my understanding.
Great. Thank you, Courtney. Any other thoughts on? So maybe we have a pin here to think about if we want to qualify this language a little more. Thank you, Kasia. All right. Any other thoughts on number 1 before we go to number 2? If not, we can go to number 2. About agencies determining if they need to coordinate with another agency and disclose the circumstances they do that. Peter?
Well, it goes back to the same thing, because if one has electronic reporting or uses of artificial intelligence in place, one is already conducting the investigation at the time that in a particular instance coordination might be called for. So I wonder whether it'd be sensible to substitute for the words before initiating in conducting.
Does that kind of capture what you were thinking when you in the report?
No.
Yeah.
It doesn't. I do think initiation is important because the tricky part with investigations is defining what it is. Certainly, an investigation can continue into the enforcement stage, but generally, as I've tried to define it, and I think the conference defines it. It's a pre-traditional agency action. It's a pre-adjudication behavior. Now, that information can come in from a variety of sources. Whether it's called an investigation or not, I think is a different question. But I think styling it as an initiation, some intentional action makes sense. The distinction between whether the information is either submitted electronically or ingested from heavy paper into ESI is it's like more technical. I do agree that agencies should consult when they're conducting an investigation too. So I think Peter's right about that also, but I think there is an important triggering point with the initiation of an investigation.
Would it then, how about introducing the word formally before formally initiating an investigation? Because at least for many purposes, investigations will be ongoing before the agency has focused on the particular behavior of this particular subject and undertaken to go forward in relationship to it.
So that's a good point. My response to it is that agencies sometimes informally investigate too. Typically, I would construe as formal investigation is some sort of compulsory information gathering process. So maybe intentional investigation might be the better word if you're looking to sort of cabinet, because sometimes agencies just unintentionally gain access to information just like by going on the internet, for example.
Well, I mean, this may be just a matter of locution, but I think when OSHA requires people to submit reports, particularly if they are submitted in electronic form and just automatically reviewed by artificial intelligence to identify circumstances that the human ought to look at, they are investigating.
I think they are
that's
too.
an act of investigation. And you to say before doing that, they have to decide who they're going to consult with. I mean, and maybe in one instance, it's the Nuclear Regulatory Commission, and in another instance, it's the FDA. I don't know. But not to find the point at which you say, and I understand you're saying it, well, agencies decide to do this. Not focusing on the point on what is actually a decision point about this particular person, rather than we have a process of investigation which is ongoing.
No, I think you have a good point there. My thinking is with regard to, so using the OSHA example, and I think you'll probably forget more about OSHA than I'll ever know. I'm focused, at least the goal of the research is to try to provide like a trans-substantive account on general investigative behavior. And just using this one example, I think that makes sense. But at the same time, you know, we have other guardrails like the Privacy Act or something that guide agency behavior when they're engaging in investigative processes. But you know, again, like outside of the scope of this project, I certainly looked to see if there was AI being covered, but many of these procedures that I was able to reveal, there's almost like no reference at all to AI, because if it's a practice, it's a norm, it's not actually enunciated in open source materials, at least for the agencies that I was researching.
Totally accepted. Nonetheless, while that's happening, investigations are going on. And
that's right. And the question is,
okay, and
is it a human actor, or is it just a bunch of computer systems talking to each other, which is probably the wave of the future? So
what you wanted, I take it what you want to do, why you resisted my desire to insert the word conducting instead of initiating. As I understood it, what you said was, well, but it's really important to identify the start point because that's the point that we want to speak to. But the start point as a matter of general agency procedure is very different from the start point in relationship to some particular subject of possible action. And I take it it's the latter that you're talking about, not the former. And
I think that's right.
Okay, so find some way to express that find some way to talk about it that recognizes that there will be ongoing processes that could be characterized as investigation, but that have not yet come to focus on any particular body. That's why conducting struck me, or formally struck me, intentionally doesn't do it, because the other behavior is intentional also. But maybe there's some other way to talk about it, but that seems to me the distinction that you should be making.
I get your point. If you can give us an opportunity to revert, for the next round,
Of course,
proposed word, because
of course.
my final thought on it is this, is that there is so much data that agencies gain access to. I certainly don't want all of that to be considered an investigation. So it's like a porridge temperature issue. And certainly when they're, engaging in some sort of intentional process of focusing on a particular use case or a particular behavior or pattern, that probably seems investigatory, but just general information within its swill, probably not. So we'll revert on that. I mean, this is like one of the $60,000 questions.
Or so again, maybe initiating an investigation of a particular subject. I mean, there may be a variety of ways in which you could do it, a particular organization rather. But I think that that's a distinction that ought to be observed.
I agree.
Thank you, Peter. Thank you. So fortunately, we have 2 more of these meetings we can have, so we have lots of time to think about this. So if anyone has other ideas on this and how to phrase it in the meantime, we definitely look forward to hearing them. So anyone else have any thoughts, edits, comments on number 2? If not, I don't see any hands. We can go to number 3.
Same issue.
Same issue.
I have something on 3. I can't figure out how to raise
Erica? No worries, Erica.
can't. I used to be able to raise my hand. It's just a small question, but I wasn't sure what work the word relevant was doing there. Relevant enforcement manuals. I worried because it said above that that an agency should do make sure that they're, maybe it's nothing. I just didn't know. Are we envisioning? It says agencies should develop an enforcement manual that includes information. And I didn't know if this is suggesting something different, that each had more than one, or some of them would be relevant and some wouldn't. I just didn't understand. If every agency that does investigations is being recommended to develop an enforcement manual with information about their investigative procedures, shouldn't that manual explain whether those investigations can be initiated independently? I just didn't understand if there was some significant cabining of the scope within relevant enforcement manuals or not.
It's a good point. I'm going to turn it back over to our drafters to see what they were thinking.
Yeah, I can take that, Helen. So I think when we initially looked at this, it was supposed to be relative, and I think that might be a scrivener's error on my part. But I actually don't think that either word does the heavy lifting that I think I had envisioned it. So Professor Litson, I think that it's a good deletion to take out the word. I think that's a good deletion.
Thanks.
Thank you, Adam. We've highlighted Peter's same concern in this paragraph. Anyone else have any other comments, edits for number 3? Courtney.
This is just a minor technical correction. If we're based on the last change, I think the commas can come out after procedures and manuals.
Thank you. All right, any others on number 3? If not, we can go to number 4. Did we want to start with Adam's question first? How should the agent?
I would offer that just to the group, to read and see how you interpret. I might put a finer point on this, just for the committee to consider at what point does providing criteria or clear criteria provide law by which judicial review becomes available. So you can take for that what you will.
I think what you're talking about is the debated question of the extent to which guidance documents are subject to review, because what enforcement manuals are guidance documents. They are not regulations that govern the behavior of people outside the agency. They are internal instructions to staff about how staff is to behave. And so I hope it's the case that they aren't reviewable because they are guidance documents.
Thanks, Peter. Sid, I saw your hand go up.
Thanks. Peter, do you think they're guidance documents or procedural rules?
You can take. I don't think
they're the notice of comment rulemaking, and as a procedural rule, I don't think we have final agency action, do we?
No, but I take it they're not a procedural rule in that, at least as I understand it, procedural rules are rules for the conduct of formal agency proceedings, and we aren't there yet.
Okay.
Ram, I see your hand went up too.
Yeah, so that's like another good question that Peter raises. The way most agencies construe of these is they're not guidance documents. They're 553 BA rules of, either rules of procedure, internal procedure, and oftentimes agencies will resist producing them in the context of a FOIA request because of whatever. Typically, they'll like throw any sort of exemption they can at the wall and see what sticks.
And seven can be quite useful in those terms.
Yeah. I mean, there's so many different ones that they'll use. So, like for example, if it's a national security agency, like it's, but the through line is like they most of them do not like posting these things. Some of them do. Almost all of the agencies have them at some level. Like OFAC does not have a completely de novo ad hoc adjudication process, well, we just currently won't know like what they are. And at least when I was at the Justice Department and every now and then like a request would come in for these things, some would view them as a 553BA rule of internal agency procedure. And whether Peter's, caveat point is correct, I don't know if that's sort of been socialized enough with the federal courts for a definitive outcome.
Well, I'll go back to OSHA again, or for that matter, the NRC, where I worked for a while, or the post office. It is really important from an internal perspective to have clear instructions to inspectors how they're to behave when they go in on inspection, or to postal clerks how they're to handle packages. And that doesn't make them reviewable rules.
I agree. I think that's right. My only reaction is that it's a bit of a gray area precisely what they are. I just haven't been able to find, a definitive Article 3 answer or an Article 2 answer. It could be all of these things. And it depends on, what the procedures are for, right? So for the Postal Service, they have all kinds of great procedures that are on the internet. And there's a huge interactive component with the regulated public.
It's useful to know how to wrap the package.
Yeah, for sure. I'm just adding something. I'm not necessarily disagreeing.
Right.
It is, for that one, it's a little tricky.
It's confounding because these things are stated in binding language, right? And normally a policy statement, we require it to be, we may do this and we may do that. But that's not very helpful when you're instructing the inspector how to go out and what she or he's supposed to do. So I think you're right. It's not, we don't yet have a clear message. The courts have never really said, hey, wait a minute, if it's internal, it's not a binding statement on anybody. It's not a legislative rule.
So let me
People
just
may
add one more.
recognize that this is an issue on which Bob Anthony and I traded quite a few words.
Yeah, a final thought, just as for the group, is one thing that's relatively certain from even informal conversations off the record I've had is that woe to the agency member of staff who does something totally inconsistent with whatever the manual or the procedures are. They're typically not going to get the favorable outcome for the enforcement that follows, and sometimes they don't have a favorable outcome from HR purposes either. So,
and sometimes if they're SES employees, they find themselves at the wrong end of the stick.
Yep.
But these are totally different issues from whether someone who doesn't like what the manual tells the OSHA inspector or the NRC inspector to do can bring that issue into court.
Correct. I made that comment bearing on, it seems like it's more than guidance, at least internally within the agency. The individual's discretion is not truly unimpeded. It's heavily impeded.
You've put your finger on the debates that Bob Anthony and I were having for quite a while, because you want internally, you want the staff to understand that these are rules. This is what you're supposed to do. On the other hand, from the perspective of the public, they aren't directly affected by it. B, they have in general a strong preference to have agencies behave in just this way, telling their agents how they are to behave. And to make those statements reviewable is to invite all kinds of bad consequences.
This is really helpful, everyone. So currently, the language doesn't say anything about making this information, like putting it on the website. So Adam, by putting this comment in here, were you seeking from the committee whether or not we should include in number 4 a statement that would make it publicly available? Or, because right now it just says we should provide clear criteria to, but it doesn't say anything about like making that publicly available. Is the idea this would be in the manual and then it would just be de facto be public available? Or were you looking to the committee to see if we wanted to add more language in here about explicitly making it publicly available or not?
Right. So I guess by adding the comment, I think it was important to have the discussion about guidance documents and procedural rules.
Mm-hmm.
And if we feel, if the committee feels that, this is going to be too tricky to draft, I think that was probably my inclination to have it as a comment and not as language. But I did wrestle with the idea of including, the last comma and being that publication of such criteria may allow for judicial review under the APA. So that was sort of where I was going with that.
Yeah.
But it is obviously up to the committee to decide what is and is not appropriate to include here.
I appreciate that. And I will just note the other thing I was thinking of was the Congressional Review Act. So at what point do you push this into the world of being like, subject to the Congressional Review Act, and then all of a sudden an agency's internal enforcement procedures might get subject to the CRA, and wouldn't that be interesting? So that was the other thing that also thinking about when you started thinking about moving this more into the world of being public guidance. So. And I think I saw you move, Aram, so I think you have a response to that.
Yeah, so if the question is a normative one, should these be made public? I think public policy supports them being made public. I have not seen a lot of success, although I haven't, intentionally done like a huge research on this, seen any level of challenge to agency rules outside of, in an as-applied setting, but that's only to the individual. Now, of course, the Supreme Court's jurisprudence probably allows for some end run for direct Article 3 access if the rules of agency enforcement are unconstitutional or allegedly unconstitutional. But I personally don't forecast CRA problems, ANC problems, for an agency publicizing its enforcement manual. So for example, like the Securities Commission has one out. It's outdated, and there's, goodness, a lot of attention on the Securities Commission for the things it can and cannot do. I've not seen this one pop up. I wouldn't expect that to take place. So hopefully that's helpful.
Thank you. Okay, with all of that, does anyone have strong thoughts or reactions? Erica, there we go.
Actually, I have something else on number not on this.
Okay, so we'll hold for 1 second to see if anyone has any thoughts or ideas about adding anything about making it publicly available, the criteria or not, or if we need to think about this one a little more and come back to it. We can do either.
It's sort of circular. If we were confident that the agency couldn't be sued over the criteria, then agencies would be more confident in publishing the criteria and creating them. If they think they're going to get sued, they probably are not going to devolve the time and effort to make clear criteria so they can get sued.
There's that, and there's also the agencies will be reluctant to publish these instructions to the extent that they serve as guidance to those who might be investigated, how they can avoid, how they can structure their behavior to accomplish bad ends but avoid investigation. So again, it's the exemption 7 type of carve out.
Okay, well, we can keep thinking about this one. Fortunately, we don't have to completely land on it today. So, all right, how about we turn to Erica?
Thanks. I actually just wondered if we could get a little bit more clarity about the second half of the sentence with due consideration for the agency's time, resources, and authority to bring a potential claim in a particular venue. I guess I just don't understand what the point is being made here. I mean, I thought maybe the suggestion was a sort of a tacit recommendation that the enforcement personnel initiate investigation only if they're prepared to bring a claim if they find certain things. I mean, I just don't know. I think there's some kind of subtle message here, and I just didn't understand what it was.
Oh, thank you. I'll turn back to Adam first.
Sure. And Aram, you can definitely jump into this, because I do think that in drafting for at least the back half in this way, I wanted to include some through lines that cropped up within your report. Agency's time and resources was something that came up repeatedly in the report. You know, agencies have to weigh considerations about what type of potential violation has occurred, how many people are working on a particular thing, the resources available, and then also the ability or the authority to bring in a particular venue is something that came up a few times in the report. And I wanted to encapsulate that. And if that is doing too much in 4, then I can definitely see that. And it might be that we eliminate, or it might be that we separate this idea out a little bit.
Is that a post-investigation issue? That is, lots of investigations occur and then the agency says, well, we've got time and resources to proceed on this one and not on that one, now that we have the information about what we might be able to do.
I guess that's what I was thinking, that is about decisions made later and not the decision to initiate.
You're muted, Aaron.
We can't
Apologies
hear
for
you.
that. I don't see a problem with the clause that Eric identified being excised from the initiating investigation section. I think that that sentence on its own is probably pretty good. It's because that there's almost no downside to personnel knowing what is appropriate for purposes of initiating an investigation. And one of the factors of being appropriate can be like, and other ad hoc considerations or something like that. And you have some flexibility built in, but as a general matter, the stabilizing a function of that, I think, is okay. But you're right. I mean, I do care about not just having this strictly monotonic agency should do more, but that any cognizance of limited resources, you know, and scarcity of time.
So period after the word investigation is what you're saying?
Yes.
Thank you. Any other thoughts or reactions? Any other comments for paragraph 4? If not, we can turn to 5, and 5's kind of long, so we can break it down. We can start with 5A.
No, can we start with the introductory clause?
Yeah, the introductory clause in A. Thank you.
The subject of an initiated investigation.
Yes.
I like that. As I'm thinking this through, I wouldn't want just like automatic audits, or for example, the IRS without some intentional initiation is technically investigating everyone every year when people submit returns. And
well, that's what AI
not
does.
A good limiting principle. So that would make sense. Okay.
Thank you. All right. Any other comments on the opening clause? Not, we can go to A. Scope and nature of the investigation. B, potential violations of statute or regulation being investigated. I would note that sometimes it can be more than one statute or regulation that could be investigated, so it might be, we could pluralize that. Or put it in. We have no comments. We can go down to C. Amount of time available for preparing and submitting a statement by the subject of the investigation prior to the agency initiating an enforcement action against them, if such time exists.
Do we mean by if such time exists that the agency has a good estimate of the time? Could you explain a little more what you were getting at in C?
I'll turn to Adam first.
Absolutely, Professor. So within the report, there were a few examples where agencies can immediately initiate an enforcement action. So I wanted to encapsulate that in there, but if that doesn't come through, I would understand that that could have a finer point on it.
I guess the reason I'm not sure about this is based on my experience, but it's a long time ago. When we went to an agency with a subpoena or some sort of investigatory demand, the response and negotiations over the scope of what we were demanding went along like something like this. We don't keep the records like that. It'll take us hundreds of thousands of hours to get that information. It's completely unreasonable. And our response was, we can't see that it would take that long. Probably the truth being somewhere in the middle. So I'm just not sure about this section, but as I say, it's an old experience.
Well, and what you've begun, this whole recommendation begins with the word, if an agency seeks information. And if the agency seeks information, if that's what this is all about, it ought always to be with a statement about the amount of time available for giving the information, for providing the information.
Makes sense.
And again, what we are talking about is in the context of an investigation that is already taking place. So I don't know why you don't again end this with the period after the word investigation.
And I see Kayla, your hand's up. Is it in response to all of this? You might have a solution for us. Thank you.
Well, I actually had two different comments on C, but the one that's more relevant right now is, do we really need the clause about prior to the agency initiating an enforcement action?
No.
With a caveat that I'm sometimes not completely sure when the investigation is initiated. It would be not uncommon at my agency to initiate the investigation before formally contacting the subject. So an example might be, let's say we have reason to believe there's been a violation at a nuclear power plant, but we don't know what individual employees might have been involved, and we might do, a dozen interviews before identifying individual X is now the subject of our investigation.
And again, this is only about circumstances in which an agency is seeking information either formally or informally from the subject of an investigation. So that being the case, the only relevant issue, it seems to me, is what begins the sentence. The amount of time available for the subject of the investigation, period.
We use the word
Right.
deadline?
Yeah.
I'm sorry, I didn't mean to cut you off.
No problem. My other comment or question would be whether we considered including a recommendation on procedures for time extensions when there's good calls. I see a discussion of that on page 25 of the report.
Thanks. Or I'm sorry.
Sure. I just wanted to add a little bit of context for Kayla on one of her points, which is your point was we don't, when does an investigation actually start? From my perspective, from like a generalist account perspective, that initial contact following notice of a potential violation, at least in my mind and in this report, is like a triggering event. There's some level of investigative behavior taking place. Now, within the agency, the term like investigation, especially if you're using the word target in association with the subject of the investigation, is sort of like a level of formality within that investigation. So there's sort of like an initial thing. So the way I'm looking at it is like the tripwire is crossed once in your examples when the NRC, the commission gets notice that there's a potential violation at a facility, and then the commission does something about that. That doing something is that initial step, but then it, there's an escalation component that still remains in the investigative phase. So I'm just sharing that with you because I think you're totally right. But I wanted to take sort of NRC speak and apply that in other settings that I've seen just to get it, into general account.
That's helpful. And I'm wondering on C if there's a little bit of like some of the confusion here is the statement that's being submitted considered something different than the response to the information request? Is that something where we're thinking like if whomever is the subject of the investigation be submitting their own statement of here's what I think happened or here's why I think you're wrong, right? Something else versus agency X saying we would like you to submit certain information, because I'm just reading C as a statement of the subject in the investigation as being slightly different than responding to information being asked for by the agency. Are we considering them two different things?
The words. 5 begins with the words, if an agency seeks information.
Yeah.
So that's what this is about.
But that's why I'm wondering if C's asking for more than just the information that the agency is seeking. Is it providing the subject of the investigation? Are we saying in this recommendation that we think that subject should have the ability to prepare and submit a statement that's something more than just whatever the information is seeking? Were we seeking to do that, or were we really seeking to just keep it to whatever the information request was? Because I would say there's not clarity in this then.
I defer to staff on that one. Do I think it's a generally good idea? Great. But I want to hear from.
Yeah, no worries. I think that if we wanted to make it more than agency seeks information, we would have to pull that out of 5. Otherwise, I would tend to agree with Professor Strauss that, if we are looking to make 5 about seek information, either formally or informally, we should stop with investigation and then move into the semicolon.
It would be possible, I suppose, to add a C and a half, as it were, that if that's desirable, to say that the agency should communicate to the subject C and a half, any opportunity it may have for challenging the nature of the information being sought. Because I take it that's what is thought to be missing.
Well, that would be F, I think. Any challenge or appeal process exists regarding the request?
Yeah, right.
Yeah.
Okay, so then there it is.
Yeah. C could just be the deadline for providing the information, requested.
For what it's worth, and I didn't directly think of this is credit to the staff. I do like the idea for maybe if the only thing being sought is just like a bunch of numbers and fields, like having a general ability to say, like for the subject of the request to say something, like just a generalized, hey, I think you're looking at this the wrong way, or this might also be available or useful to you. It seems to me like a good idea.
Maybe F should become D, and D and E follow it. Because I take it that's where this would come in. So we have C, and then we have D, whether any challenge or appeal process exists regarding the request. And E, whether the information sought is being, and so forth.
Can I ask, do we have a definition for compulsory when we're using it in this context?
Yeah, so if we turn back to the preamble, I believe we have compulsory process there. And
It's
if
in
not,
H.
RM defines that very well in the report, so we would be able to add that easily.
And recommendation 8 also has that in it.
Okay, here we go. It's on page 2. It solicitations for information involve agency mandated information gathering, which includes subpoenas, warrants, or letters of inquiry. Okay.
I want to add just one other thought. What I did not include in the definition is when a non-compulsory request can be construed as compulsory, where the agency has a long practice of, if the recipient of the non-compulsory request does not provide that information, there's a high likelihood of an immediately following compulsory request. I just drew the line at actually compulsory. Some might want to draw the line at more of like the wink wink nod nod level. Don't irritate your regulator.
All right. Sorry, I got a little sidetracked there. With the edits on 5. Anyone else have any other edits, comments, concerns with the way it's been rewritten?
Can you remind me of how it's been rewritten, please?
Sure. We've now taken C and we've just changed it to include the date by which the subject must submit the information or otherwise respond to the request. F, we've moved up to D to so the challenge or appeal process exists regarding the request is now highlighted, so it's not at the bottom. So that takes the concept of that whoever is the subject of the investigation is able to, they know that they're able to question or challenge the investigation up front rather than putting that at the bottom of 5.
And was there consideration of including a provision for requesting an extension of time to respond?
You can even put that in C.
Yeah,
Time
so I was
gives you-
gonna say for
Mm.
C, I did add or otherwise respond to the request. We can add otherwise respond to the request or request an extension. Or if you think otherwise respond to the request would encapsulate that. I don't know if you have a preference, Kayla.
I guess my preference would be to specifically say request an extension.
Does that work for you? Just including a comma after request, including procedures for requesting an extension of time.
That works for me.
Okay, thanks.
Excellent. Anyone else have any other edits, comments on number 5? Don't see any hands. We can go to 6. This is that agent. Sorry, computer keeps trying to restart. Sorry, everyone. Agencies should develop clear procedures and include such procedures in enforcement manuals for how they facilitate the exchange of information and evidence between the subject of an investigation and the agency, and between enforcement personnel and higher level agency staff or officials. Any thoughts or edits? I don't see any hands. Guess we can go to 7.
There's there's an order question,
Okay.
not anything to do with the merits, but this is more about starting enforcement than it is about conducting the investigation. And so I wonder if it doesn't properly come later in the set of recommendations. I mean, when you talk closer to or as part of negotiation and settlement or end stage procedures, because now we're getting to investigation has been conducted in accordance with this excellent recommendation, and now let's think about what happens next. Doesn't have anything to do with the merits, and I'm happy to have the staff just think about what the proper order should be.
Sure, no, great point. Thank you.
Thank you, Peter. Anyone else have any other Substantive, oh, Matt, thank you.
There are some agencies that address the sometimes difficult question of how to assess conflicting evidence at the investigative stage. The agency I know best is the NLRB. What do you do, for instance, if you have a material issue of disputed fact, to sort of use summary judgment language? I'm just wondering if this is something that has arisen in the research and whether the committee should say anything on that subject. The answer may be no.
Good question, Matt. It didn't come up in the research. I know this exists, but it's a level of nuance. This question actually ignited in my mind. Recognize that agencies may have enforcement manuals that are online. So, for example, CFPB, SEC, but then they also have SharePoint sites. They have some, internal non-public documents that typically get to this level of nuance if those documents exist. So, from an outside perspective, there's really nothing I picked up in my sonar sweep of the 8 or so agencies. But that doesn't mean that that phenomenon doesn't exist and that there aren't processes that agencies use to resolve fact finding, or what is good fact finding. How many significant figures do you go? What is statistically significant? Like how do you run regression analysis? All those different types of things where you're trying to find out what facts are. Many agencies kind of have that built in at some level or another.
Yeah, no, that makes total sense to me. I think you're right. There are a lot of granular issues here. What do you do with 8 levels of hearsay and so forth and so on? But I think you're right.
Yeah, I mean, the only time I've seen that come up was this one case about reliable hearsay involving HHS, like Social Security Administration. But ultimately, the courts have concluded reliable hearsay is okay before agencies. But that would be in the context of a formal adjudication. For investigations, there's just like almost nothing to be found. But of course, they're thinking about it.
Yeah, no, thank you. I think your instincts are exactly right.
Thank you. Any other thoughts or comments on paragraph 7? Recommendation 7, sorry. I realize we're in the last 9 minutes, so we'll see what we can hit before we break for the day. We've done very well today, everyone, so thank you. On to compulsory processes. Erica.
I wonder if it should be tethered to specific conduct could be made a little clearer. I don't understand what that phrase means. The tethered, I just didn't understand it. Maybe there's a way to phrase it. It's just plainer English.
Thank you. Adam?
Yeah, I can take that. So I thought that this language was really important and it's reflected in the report. So tethered in this instance, to me, is just connected. That could be a better way to phrase this, but I did think that the report did a good job of saying that when compulsory process exists and is used, there is a specific conduct that's attached to, that's connected to. Just the language in the report was tethered, and I thought that was appropriate.
Can you explain? I mean, what does it mean to say that a process should be connected to specific conduct? So, in other words, imagine a letter of inquiry. What does it mean to say that letter of inquiry should be connected to specific conduct? Are you saying it should be precise in what it is asking about? What exactly do we mean here? And I understand it might be in the report, but of course the recommendation has to stand on its own at the end. So
I think I had a similar comment. What is an example of a subpoena not tethered to specific conduct?
Right. So definitely Arm, jump in if I'm not doing the idea justice. But when I think about this, we're dealing with a specific violation, whether that be of a regulation or a statute, and that is what is tethered to the compulsive or the compulsory process. Is that jiving a little better?
Well, so then what you're saying is a subpoena or a letter of inquiry should be precise about the statutes or regulatory provisions that it relates to? Because if that's the point, that's what it should say.
That's duplicative of
Yeah. I mean,
5.
that raises a different issue, but that's what I'm trying to get at. I mean, what exactly does it mean? What are we saying a subpoena, warrant, or letter of inquiry should I mean, yeah, I just don't understand the precise recommendation. Like if you were going to operationalize it, what would you take away and say, okay, this has to what?
If I could jump in, just give my thoughts. Certainly at one end of the spectrum, we wouldn't want name a large company getting a letter from the NLRB. Please provide evidence that you're complying with the National Labor Relations Act in 2023. Right? Like that's super broad. You also don't want to, there are some circumstances where being so specific can actually be adverse to the agency's interests. But generally the point was about specificity as to alleged conduct that gave rise to the compulsory process. Simply put, the target of the compulsory process, whether it be a subpoena, warrant, letter of inquiry, needs to know what is being sought and why, as opposed to the giving the appearance of we don't like you. Just give us a bunch of stuff. We're doing a fishing expedition, and maybe we'll find something that's wrong with you.
Could we say
So-
that? It should be precise about what is being requested and why, if that's the point.
So it's not necessarily about what's being requested, but it's about the conduct that gave rise to the request as well. I think that additional nexus is an important one. But yes.
So it should say the conduct that gave rise to the process and why or something. You understand why I'm asking. I just don't understand. I worry that it's not precise enough or clear
No,
enough
I'm
for an
following
agent
you.
to implement.
I completely follow you, Eric, on this. So yeah, I think having, and I'll defer to Adam on this, but I think it's having specificity on what is being sought and the conduct on the part of the regulated party that gave rise to the thing that's being sought as well. How we formulate that in text, I leave to ACUS staff who have greater familiarity with these recommendation processes.
We can absolutely revisit that, Aram, and Professor Litson, we'll do our best to encompass the arise out of sort of language to make sure that's a little bit clearer, and then we can reevaluate next meeting if that's all right.
Great, thanks.
Is part of the concept of specific conduct stating the date on which the investigated conduct occurred to the extent that the agency knows that? And is that something that you might consider including in the recommendation?
I think that would make sense, but that there are many agencies for which that might be a little limiting. So if we put some proviso, like if possible or if practical, something like that. So for example, for your agency, if it's like a specific thing happened at a specific site, in a specific violation, you have all of the things that are needed for that. If there's let's say like a disparate impact concern, that might be a broader array of things that are being sought because the nature of the violation is based on a number of outcomes over a period of time. And I just don't want to, it's all about sizing it correctly for the entire executive branch.
I understand.
All right. Well, thank you for the great input on recommendation number 8. I think we are at pretty much time for the day. So with the 2 minutes left to go, is there any housekeeping, Kaja and Adam, you'd like to do before we wrap up for today?
Not too much for me, other than, we'll circulate a revised recommendation with incorporated edits. We certainly welcome any other additional proposed edits via email. Our next meeting, I believe, is March 28th. Is that right, Ellen?
Yes, March
Okay,
28th.
thank you.
That is correct. No.
Okay, just wanted to make sure. And we'll just send all of that out. Certainly reach out to me and or Adam if you have any questions on this. But other than that, I think this was a very productive meeting for an hour and a half. So thank you, everybody.
Bye-bye.
Thank you, everyone. Have a good afternoon.